All right, good evening, everyone. Thank you very much for coming this evening. I know we've got stiff competition for a certain other international event that's happening. So I'm Mercy McBrayer. I'm the head of arbitration professional practice for the Chartered Institute of Arbitrators. We are very honored to have been asked by the Law Commission to work with them in hosting this event this evening. As you probably know, the UK government asked the Law Commission last year to review the Arbitration Act 1996 and whether any amendments were needed and to ensure that it's for purpose and further promote the UK as a leading nation for commercial arbitrations. The consisted of invitations on certain where the Law Commission invited comment from practitioners. Many practitioners, I believe, responded. And as a result of that, a preliminary paper was put out. And many of you, I hope, have read the paper. And if you have not, please do read the paper, because part of the purpose of this type of event is to get people to submit their comments to the Law Commission for their final paper, which is coming out next year. The comment period ends on December 15th. So if you haven't submitted your comments, please do so. So we are very privileged to be able to have this event with the Commission and to have with us the Law Commissioner for Commercial and Common Law, Professor Sarah Green. She was previously Professor of Private Law at the University of Bristol. She was a Professor of the Law of Obligations at the University of Oxford, having been a lecturer at the University of Birmingham from 2001 to 2010. And before embarking on her academic career, she was a software consultant at Accenture. She's written books and articles on a variety of issues, including virtual currency and blockchain issues surrounding intermediated securities, smart contracts, sale of goods law applicable to digitized assets, negligence, and wage theft. Professor Green, she is going to share with us the Law Commission's perspective on this, and we are really looking forward to hearing what you have to say.
Thank you, Mercy. What I propose to do today, I know there are people here who've heard me say quite a lot about our consultation paper already. So what I really want to do before I hand over to my colleagues on the panel, and I'm sure there will be some, and I hope there will be some discussion with those of you in the audience, is just to say a few words about what the Law Commission is and how we work for anybody who is unfamiliar with that process, because that is really, really important. I think it is often misunderstood exactly what we do and how we operate. And for the process to be as good as it can be, I just want to underline a few points. The first of which is that the consultation that we engage in is absolutely genuine. So as Mercy said, we have published a consultation paper that has provisional proposals in it, and that consultation period runs until the 15th of December. Even putting those proposals together was a process in itself of consultation, as a lot of people in this room will know, since they were involved in it. So our provisional proposals are based on consultation, based, of course, on our independent in-house research. It's also very important to note that we are independent from government. We are commissioned by government, but they do so with a view to the process being conducted in a non-party political way. So that's another important point to make. And then the proposals in our consultation paper, certainly some people will be relieved to know, are provisional. And so what we are asking for now are genuine and sincere views as to whether those proposals should be taken forward or not. We absolutely do listen. It is incredibly common for the proposals that we make at consultation stage to change between that point and a final report. And there's no reason why this one should be any different. If there's anything to say about how this project is different, perhaps, to some other Law Commission projects with which you might be familiar, and certainly with which I'm familiar, is that we started out very much with a view not to make any dramatic changes. So there was never any belief that the Arbitration Act 1996 needed to be overhauled in any way, and certainly not starting from scratch. We really were considering whether there are any sort of tweaks or modifications that are necessary to make sure it stays as good as it can be 25 years on. So please, I'm sure you won't anyway be backwards and coming forwards in saying what you think about our provisional proposals. So the only other thing that I am going to do today is run through, and I will run through the main proposals that we have made. And when I say main, what I really mean is those substantive proposals that have their own chapter in the paper, and those which also are very likely to attract the most discussion, and certainly have done to date. So the first of those is confidentiality. So as I said, when we put these proposals together, we based these sort of headline points on what consultees told us that they thought, we call them stakeholders in a sort of very generic way at the Law Commission. That's anybody really who's interested in the topic that we're dealing with. And the first of those was confidentiality, because we heard from some quarters that it might be a good idea to put something concrete in the Arbitration Act about confidentiality being the default rule for arbitration. We've decided, when I say we've decided at any point so far, you can just, in future rather, you can take that as meaning that I mean as far as the provisional proposals go. So at this stage, we have decided not to introduce any explicit terms about confidentiality in the Arbitration Act. That is for a number of reasons. Amongst those is that it isn't, of course, the case that confidentiality is the default position for all arbitrations or forms of arbitration. And in fact, sometimes transparency is the touchstone of, how that process is expected to work and how, in fact, it does work. There is also, of course, the point that confidentiality in itself is incredibly difficult to codify. It is not an easy and discrete concept that we can slip into any statute, let alone a statute that mostly deals with arbitration. So we have decided that actually there is that there isn't the need really for that to go into the Act that would balance out the difficulty of A, drafting it, and then B, having it as something from which a lot of parties would anyway want to opt out. So the second point that I just want to touch on is something else, of course, that was suggested to us, which was about putting something in the Act about arbitrator independence. Now, when we considered this, our provisional proposal is not to do that. When we considered this, we really focused on the idea that actually what's really important for arbitrators is their impartiality, and that is not always necessarily correlated with independence, and that actually also, in a practical sense, it's not always possible for arbitrators, certainly in certain areas, to be independent, and not necessarily always desirable, given that they are often selected for their immersive experience in a particular area. It is, of course, very important that they are impartial, but as I said, that's not a necessary correlation with independence. So what we have focused on in the consultation paper is a duty of ongoing, or an ongoing duty, I should say, of disclosure, so that we really pay more attention to that impartiality requirement than independence in its own right. Then we come on to discrimination. So this is a proposal which suggests that, in line really with the Equality Act 2010, and outside of those situations in which any protected characteristic is retained as a proportionate means of achieving a legitimate aim, we suggest in the paper that arbitrator appointments cannot be challenged, or should not be able to be challenged, on the basis of a protected characteristic. The next point is immunity of arbitrators. So obviously section 29 does provide immunity to arbitrators, but there has been, as a result of case law, there has developed an issue whereby arbitrators can become liable for costs where their appointment has been challenged. That, of course, can be incredibly expensive and is not something we hear that is covered by professional indemnity insurance. There is also another issue about, well, a similar and related issue, but that arises out of arbitrators resigning and the same point applying there. So, of course, the knock-on effects of that could well be to undermine an arbitrator's ability to act in a robust and impartial way. So we would suggest that something in the Act to ensure that that immunity extends to costs would be very helpful. Summary disposal. Summary disposal is, of course, something that probably is possible and is very likely to be possible on a reading of the Act as it stands. But what we have heard is that there is an element of due process paranoia, which prevents some arbitrators in some circumstances from summarily disposing of an issue which they otherwise would. And one of our suggestions in the paper is that by putting something expressly in the Act to allow for that, that would go quite a long way. So we hear, or so we have heard thus far, that would go quite a long way towards mitigating the effects of due process paranoia. Then we have section 44 and interim court orders. This is real lawyer's law, this one. But the question is whether those orders can bind third parties. We think they can, but again, is it a good idea to put something explicit about that in the Act? And the other issue there relates to emergency arbitrators, which were, of course, not a thing when the 1996 Act was drafted. And the question then is, how does section 44 and emergency arbitrators interact? Do we need to have, so we've taken the view that it isn't appropriate for the whole Act, of course, to apply to emergency arbitrators in the same way as it does to non-emergency arbitrators, but what is the best way of addressing that? Is it to have a separate regime for those emergency arbitrators, or is it a question of making it, again, an express inclusion of those emergency arbitrators within section 44? And then on to everybody's favourite topic, it seems, which is section 67. So should appeals under section 67, where a party has participated in arbitration proceedings, I'm not going to say too much about this because I'm sure someone else will, but we suggest in the paper as a provisional proposal that that hearing should take the form of an appeal rather than a de novo hearing to reduce the ability really for parties to have what could be seen, I suppose, in some cases as a disingenuous second bite of the cherry, to use the initial hearing as a dress rehearsal, and then to find out how better to present a case when it comes to court for a de novo hearing. As I said, I think I'm going to leave that one there. And then finally, the last sort of substantive topic that has a chapter of its own. So in the paper we have chapter 10, which deals with sort of miscellaneous issues, and then chapter 11, which lists all of those things that were suggested to us that we at the moment don't propose to pay any more attention to. But the final sort of substantive point really that I'm going to touch on tonight is appeals on a point of law. Section 69. And really, this is one that has attracted quite polarized views thus far, or certainly up to the stage of consultation paper. Some people telling us that actually we shouldn't have an appeal on a point of law at all. And so really thinking about the ultimate finality, I suppose, of arbitration hearings. And then others telling us that actually the ability to appeal under Section 69 should be less limited than it currently is. We at the moment take the view that it's fine as it is, and that the status quo actually achieves quite a good balance between those two things, particularly when looked at in a comparative context. There is not an obvious comparative example, we don't think at the moment, that works better than what we already have. And of course, Section 69 is not mandatory anyway, so it doesn't necessarily bind anyone to anything that they don't wish to include. So I'm going to stop there. As I said, I'm sure there are other people who are going to talk about some of those points in more detail than I have. So yeah, Mercy, over to the next.
Thank you, Professor Green. So now that you've heard sort of a summary of the Law Commission proposals so far, what we're going to do now is hear from 4 experts in the field with their various views. And we're going to start with Professor Julian Liu, who is with us, who's joining us online this evening. Julian is a full-time arbitrator in international commercial and investment disputes and has been involved with international arbitration for more than 40 years as an academic, counsel, and arbitrator, being appointed as sole presiding and co-arbitrator in numerous arbitration under the rules of all major arbitral institutions. His professional expertise covers a wide range of subjects, including international transactions, investment law, purchase and sales, joint ventures, oil and gas, and the list goes on. He's written many books and is professor of international arbitration and the head of the School of International Arbitration, Center for Commercial Law Studies, Queen Mary University of London. I was privileged to have him as a professor when I was doing my LLM there. And he has held these positions at the school since its creation in 1985. And an interesting little tidbit for you is that Julian actually chaired the consultation committee for the Chartered Institute of Arbitrators on the development of the 1996 Act. So we are very privileged to have his long view and his perspective on this. Julian, welcome.
Good evening, everybody. Thank you, Mercy, for your introduction. First of all, my apologies that it was not possible for me to get back as I'd hoped to London in time for this evening. But I am delighted to be here and looking forward to hearing all the discussions from Jerusalem in Israel. These are very interesting times for arbitration, generally, and particularly for English arbitration today. There's been so much discussion about ideas for changing, updating, upgrading the Arbitration Act of 1996. And we've received the Law Commission's consultation paper, which is constructive and helpful, and clearly a lot of thought has gone into it, and we benefit from that. But let me start, in a typical professor's way, first with a fundamental question. What is the role of arbitration as a dispute resolution mechanism in England going forward? Who does it serve? And what are the major functions of the mechanism? If arbitration is international, what support is it given by national law in the UK, as opposed to national law's attempt to blend the international system to its own procedures and controls? In summary, in my view, any changes to the Act should reflect the interest of the users. And by that, I mean those who come to England for arbitration. Following the old adage, which I know is being used by many in this discussion, if it's not broke, don't fix it. In simplistic terms, we should not forget that the choice of arbitration to resolve contractual disputes is effectively a rejection of the otherwise appropriate national courts jurisdictions? What do parties want from the courts whose otherwise jurisdiction they have excluded? I suggest they want those courts to uphold the arbitration agreement, to support the process, if so requested, and to enforce the award that is issued subject to limited exceptions. And as a background to this discussion, allow me to share a little history of the period of the last two Arbitration Acts of '79 and our existing legislation of 1996. There was not much international arbitration coming to England in the 70s and 80s. France and Switzerland, by my recollection, were bigger arbitration centers. Why? Despite it being the center for shipping and commodity arbitrations, English law being well developed and a recognized and respected high standard, the business world did not like English arbitration law. Why? Because of the case-stated system, which allowed arbitral decisions to be reviewed by the courts, and the English courts were considered to be too interventionist. And I'm not an economist, but if I may say, people buy into a system because they have confidence in it, or they don't buy because that's not what they want. There was also a concern that if they came to England for arbitration, they would find themselves having to follow English procedure, and that matters held in arbitration, where with cross-examination and document disclosure, English style. I remember in those days, the number of English lawyers who would come to an arbitration in England, an international case, carrying the white book. The question is whether that was applicable. So England was always respected, and still is, for an excellent substantive law for contractual and commercial transactions, quality lawyers, outstanding judges and court system. And so parties could, when they wanted to, and still do, come to England to use the court system here. And let's not ignore that. We're talking about a different system where parties have selected to go to arbitration. The adoption of the 1979 Act did little to enhance arbitration in England. In large part, the form of arbitration law, as it adopted then, made little change substantively and dissuaded parties to coming to England generally. And there was a lot of discussion amongst in legal circles. There was a lot of work that was done by the Law Commission and the Department advisory committees. Various issues that were raised, some of which we heard earlier from Professor Green, are on the table again, and perhaps rightly so. But some believed that our system was international and did not need specific assistance from anything international because our system was so good, it was better than anywhere else. And there are cases of that sort which left people unhappy outside England. A further factor was that some believed the application to the courts for arbitration in England was essential for the development of English commercial and contract law. And that matter was raised by a former Lord Chief Justice a few years ago. And happily, we've heard not much more since then. In my view, international arbitration is an international and not a purely English system. And times were changing in the 1980s. First, there was recognition that international arbitration was more than just parties being from different jurisdictions. They expected a procedure that could be adapted for their specific needs. They wanted something that was neutral. They wanted arbitrators who were neutral. They wanted arbitrators that came from different places. And there needed to be an accepted system of rules and practices for those types of arbitration. Hence, we see the work of the United Nations, initially through the Economic Commissions for Europe and Africa and the Far East, and in particular, the development of the UNCITRAL arbitration rules in 1996. That was a major effect. In the early 1980s, the LCIA, then known as the London Chamber of Arbitration, was revived, restructured, new rules, new approaches, understanding the needs of the developing commercial world in our beginning of globalization, and a willingness to start dealing with arbitrations on an international rather than a more domestic basis. And they accepted. Parties wanted flexible, sometimes foreign procedures, lawyers from different venues, different countries to be able to represent the parties. There was also an increasing interest in arbitration as an international practice. Arbitration was recognized not just as a procedure according to the seat of arbitration, it was an international process of its own. Now, when we started the School of International Arbitration, and nobody will be surprised that I mentioned this, at Queen Mary, we had a focus, and our focus then was arbitration is an international system. And what does that mean? It's a system which is based on international law, public international, private international law, comparative law, because the ingredients of many of these international systems involve those areas of law. That didn't in any way preclude parties from choosing the applicable law, deciding on the terms of the law, and also, of course, it upheld contracts that were made to be contrary to public policy or fraudulent or in other ways. But essentially, it was recognizing that we had a different system. Following the success of the UNCITRAL rules in the mid-1980s, we have the UNCITRAL model law on commercial arbitration. It was developed with the participation of the major countries or the major arbitration countries, and it was meant to be a law that everybody could adopt. Interestingly, many countries have, and today it is widely accepted across the world. But I'll leave you with a question. This is a little bit rhetoric. Isn't it interesting that those countries that think they are the major arbitration centers, England, France, United States, Sweden, Switzerland, have not adopted the model law? We've adopted some of the factors coming out of the model law in the 1996 Act. But there is an issue there that the law was good enough for others, but not for us. But the advantage of the model law is that if you're sitting in Mauritania and somebody wants an arbitration in Utopia, and both countries have the model law, there is a feeling from lawyers and from parties, oh, their law is the same or very close to the law that we have. Well, there were many discussions, working groups, interest representations in the mid-1990s in connection with the new Arbitration Act. And as was mentioned earlier, I was privileged to chair the Chartered Institute committee, which made representations. And having heard Professor Green about the views of that have been expressed, diametrically opposed views on sections 67 and 69, I recall that same discussion was taking place at that time. And as I've indicated, my view has always been if parties want to go to arbitration, subject to very limited exceptions, they go to arbitration, and that's where the decisions should be made. And that's because not only in the United Kingdom, but around the world, most systems of courts are excellent, and judges want to get it right. Now, one of the interesting factors, and I think it's worth mentioning this, because it was an influence on the 1996, was a tussle between the establishment of a private working group and the DAC. The DAC was the government, the state's system for looking at the new Arbitration Act. But a private group was set up by the late Arthur Marriott of practitioners and others who were interested. And there was a view that the establishment, under the chairmanship of a senior judge, was not listening to the voices of everyone around and was not understanding the international side of arbitration. The Marriott Committee drafted a private act, which was simple, clear and easy to read language. One of the arguments was that foreign lawyers who were considering or in fact came to England for an arbitration should be able to read and understand the Arbitration Act, a little bit like the model law. Eventually, the two opposing groups merged, and under the chairmanship of Lord Savile, with the help of Tony Landau, the Arbitration Act 1996 was finally concluded. And one of its major, most important factors is the clear language in which the Act is written, easy to read and understand. That doesn't mean that some of the issues are not still complicated and lawyers argue and ponder over some of these provisions. But ultimately, it is not in the old-fashioned parliamentary language. And that has been a major, major advantage of the Act. So with the Act, the proof of the pudding is in what we've got. The 1996 Act has been a great success. How do we know? Well, we had very little cases coming to the United Kingdom. But after the 1996 Act, more and more cases came. Ad hoc cases have come, other institutional cases have come, and also the LCIA with its own proof. And I don't wish to take anything away from anybody, but the Act itself is the fundamental basis for arbitration in England. So I was one person who felt at the time that the Arbitration Act 1996 was not as radical as it should have been. But there were others who thought it went much too far. But we are where we are. And as I say, the proof of the pudding has been in the eating. So we come now to where we are with the work that is being undertaken by the Law Commission. And the question I ask again is, with respect to proposed changes from the 1996 Act, are they necessary? And I don't want to get into talking about some of the provisions, which I know others will address. But our law and our court will be supportive. And a perfect example of that is in the area of confidentiality. And I know I personally, and through the Chartered Institute, wrote to the DAC all those years ago, recommending and suggesting and even proposing a draft language, which suggested if we want confidentiality, it should be legislated for. But it's a very difficult issue, and no doubt the Commission is looking at that at the moment. So again, I come back to what I would suggest in going forward. First, the existence of every arbitration is based on party autonomy and an express exclusion of the jurisdiction of national courts. And I suggest there we should be strictly limiting the cases where one can take an arbitration after decisions have been made. And I include here the question of jurisdiction, although I understand that's more complicated, whether those should be allowed to go for a second bite of the cherry to the court by a party who feels it has not got the decision that it wanted. And secondly, we should appreciate this. There are other jurisdictions, competitor jurisdictions, if you like, who are excellent. They have good law, they have good lawyers, and they have experience of arbitration. I think that's an advantage to us. Why? It's like any business. There's a competition. Competition is good because sometimes parties will want to go to one system and to the other system. And we should be happy with our system. And if there are aspects of our system that people don't like, just like in the 1970s and 1980s, they won't come to England. We're not going to get a monopoly in all the arbitrations coming, but we want to have a law that is fair and reasonable and effective. And so with that, I bring to the end my comments, and I would just say that once again, I do commend the Law Commission and wish them fair sailing with all the really hard work that they are doing. Thank you very much.
Thank you, Julia. I apologize. I'm recovering from bronchitis, so if you give me just a moment. Well, I really enjoyed hearing the historical perspective myself. We're going to switch now over to Professor Brekaloukis, and hopefully my voice will recover by the time he's done speaking. But Professor Brekaloukis is another of my former professors that I'm privileged to be here with. He is also professor at Queen Mary University of London, but is on sabbatical this year, yes?
Correct.
And is an arbitrator practicing from 3 Verulam buildings at Gray's Inn. He's been involved in international arbitration for more than 20 years and is widely recognized as a leading authority in the field, regularly listed in Who's Who Legal for arbitration, construction, law, and also thought leadership, and is currently in the Legal 500 arbitration power list and ranked as a global elite thought leader and one of the 25 most highly regarded arbitrators in the EMEA region. He's been shortlisted twice for the GAR Best Prepared and Most Responsive Arbitrator Award and received the 2020 GAR Award for Best Public Speech, which I have to mention was for the Chartered Institute of Arbitrators Roebuck Lecture that year, so thank you. He is regarded as a leading academic in the field of international law and arbitration, and is also the editor-in-chief of the Chartered Institute of Arbitrators Academic Journal. Thank you, Stavros. We're looking forward to hearing from you.
Well, thank you so much, Mercy. That's very kind of you. I need to start by thanking the Law Commission, Sarah and Nathan and their team for the tremendous work that they've done in reviewing the Act. Reviewing the Act that has been in place, in force for 25 years, is not an easy task, not least because it doesn't only implicate a number of different legal and policy issues, but also implicates a large number of stakeholders, as we heard Sarah referring to them. The Act is not just a piece of legislation. It is an important element of London's thriving arbitration practice and needs to be carefully considered any amendment of the Act. So here, the Law Commission had to address not only the broader big issues. Do we go for an extensive reform, or do we just update the Act? Do we even touch an Act that has been working so well for 25 years? They also had to address some more narrow policy doctrinal issues, such as the question of confidentiality and the question of Section 67, which I will come to in a moment. So I would argue that the Commission has done a wonderful job on both of these fronts. They have addressed the wider questions, the wider threshold questions with balance, and have addressed the doctrinal and policy questions with rigor. And this is the sense that I get from speaking to my colleagues, both at the bar, at the city, but also international fellow arbitrators that I sit with. Now, having said that, there are 2 matters that I want to discuss today. The first is the question of confidentiality. So I referred to what is the current law and what is the proposal of the Commission. Very briefly, the current law is that in most cases, every arbitration that is seated in England and Wales is considered by default to be confidential, private and confidential. The Commission proposes not to change that, but also not to include any express provision in the Act. And so the law of confidentiality to be developed, to continue to be developed by the courts. I understand the reasons behind the decision of the Commission, and I think that these work very well as regards entirely commercial matters. However, in my view, there's one area of law, there's one group of arbitrations, which I'm not sure that the current proposal for a default confidential provision for the default confidential rule will work very well. And this is the arbitrations that arise out of procurement contracts or any other contract that involves the public interest, the tax monies, the taxpayers' monies, and some big public policy debates. I'm saying that because the Arbitration Act has never been designed to cover these arbitrations has been designed to cover only purely commercial arbitrations. So this category of arbitrations, what I call the public-private arbitrations arising out of procurement contracts, are not covered by either the Arbitration Act or the law of confidentiality as it has been developed by the courts. As a result, there have been in recent past some disputes in relation to public contracts which went wrong and which were dealt with in an entirely confidential setting. And a typical example here, I refer to a widely known dispute that arose between the UK government and the US defense company Raytheon for the implementation of an electronic system to vet travelers entering and leaving the UK. The arbitration in this dispute decided the matter in an entirely confidential setting, deciding that the Home Office had unlawfully terminated the contract and awarded Raytheon a substantial amount of damages. Now, in those circumstances, I think there's a powerful argument that the UK public has a right to know what went wrong, who they are need to hold accountable for a public contract that went wrong, and had serious implications both for the public finances and the UK border security. In civil jurisdictions that have developed a well-developed system of administrative law, this dispute would have never been remained confidential. There's a sound argument, in my view, that the amended Act should carve out these disputes from confidentiality, the default rule of confidentiality, inserting an express provision to that effect, so that these kind of disputes that implicate the public interest be resolved in accordance with fundamental public law norms of openness and accountability, which should be reminded are part of the great common law tradition of the rule of law. Moving to the second issue, namely section 67, which we've heard and we know by now that has turned out to be the most controversial, the most contentious proposal in the consultation paper. The proposed amendment was briefly summarized by Sarah. Just to remind that what is now proposed is that the party that has participated in the arbitration proceedings, I think that's an important point to know, and has objected to the jurisdictional tribunal, then if that party brings any challenge against the tribunal's ruling in the context of section 67, should do that only by way of an appeal and not a de novo rehearing. There are competing considerations that are implicated in the proposed reform under section 67. On the one hand, there are arguments against the proposed reform. For a start, arbitration is strike law to say it is a consensual process. The right to challenge an award by way of a full rehearing offers an important safeguard to a party that maintains that it never consented to the process in the first place. Further, there are empirical data and experience that suggests that section 67 applications tend to be rare, and they are mainly decided without hearing witnesses. However, in my view, there's an important principle of fairness that supports the proposed reform. Under the current law, we heard again that a party can participate in the arbitration proceedings, challenge the arbitral tribunal's jurisdiction at a full hearing that involves witnesses, documentary evidence, expert opinions. If that party is successful and is challenged before the tribunal, then it will obtain a favorable award and foreclose arbitration. But if that party is unsuccessful in this challenge before the tribunal, it can then further have, as we heard, another bite of the cherry and challenge the arbitral award before the courts, again having the benefit of a full rehearing that may include fresh witnesses, documents, and expert opinions. This is a powerful consideration, in my view, a powerful consideration of principle, and I agree here with the Law Commission's observation that the party cannot be allowed to treat any challenge before the tribunal as a kind of a dress rehearsal. Furthermore, the proposed reform of section 67 is support considerations of finality of an arbitral tribunal's decisions which we need to remind ourselves that is also an important public policy of English law. Finality is an important public policy of English law. It has also rightly been observed that in litigation, it is common for issues in a case, including dispositive issues, to be subject to challenge by way of an appeal only. It is not clear that there is a principled basis for adopting a different position, a different approach when it comes to arbitration. Finally, it must be noted that the proposed reform, rightly in my view, maintains an important safeguard for any party that has not participated in the proceedings, who will still be able to have a full rehearing by challenging the award under the combined effect of sections 72 and 67. Thus, on balance, and subject to 2 points that I will come now very briefly to, I favor the proposed reform of section 67, both on the basis of fairness and principle of finality. The 2 points concern the impact of the proposed amendment, first on section 103 and then on section 32. As regards section 103, I think that if the right to a hearing is abolished for jurisdictional challenges in the context of section 67, the right to a hearing should also be abolished for jurisdictional challenges in the context of section 103, in the context of enforcement of foreign awards in England. There are neither practical considerations nor principled basis to distinguish between these two circumstances. This is particularly the case because 103 of the Act covers foreign arbitral awards, which enjoy the benefit of New York Convention of the enforcement of foreign arbitral awards. And again, we need to remind ourselves that foreign arbitral awards are presumed to be enforceable under Articles 4 and Article 7 of the New York Convention. So I do not think that the Commission's analysis here on this point has given these adequate consideration. As regards section 32, here the consultation paper asks whether if section 65 is limited to an appeal, whether the same limitation should apply to section 32. I think there's a distinction to be made here as regards section 32. The distinction is between the case where a party applies to the court before the tribunal has ruled on its own jurisdiction, and the case where a party applies to the court after the tribunal has ruled on its own jurisdiction. Section 32 currently treats both cases equally, but I think there are different considerations implicated in those two circumstances. Specifically, when a party applies to the court after the tribunal has ruled to its own jurisdiction, I agree. This party should not have the benefit of a de novo hearing. There's nothing that distinguishes this case from the case when a party challenges the award under section 67. However, when a party applies to the court before the tribunal has ruled on its own jurisdiction, this case should be treated differently, and I explain. Asking a court to decide a jurisdictional question as a preliminary matter can save time, can save costs, and can reduce uncertainty. If the court decides that the tribunal has jurisdiction, then the route to section 67 will be foreclosed. If the court decides that the tribunal lacks jurisdiction, then the parties will no longer need to spend any time and any costs to continue with their arbitration. In either way, the parties will know where they stand before having to spend substantial amount of time and money. Therefore, there are sound policy considerations for a law reform to incentivize the use of section 34 by parties before the tribunal has ruled on its own jurisdiction, over the use of section 67 at the end of the arbitration process. And I'm saying that especially keeping in mind that typically English courts deal with preliminary matters in a quick and efficient fashion. And therefore, there's no risk that a party can use Section 32 to stall the arbitration proceedings. Thus, in my view, in such a case, the Law Commission may consider to relax the current stringent procedural requirements which are set out in Section 32, which include the requirement that before a party asks a court to rule, that party needs to take the agreement in writing of all the other parties or ask permission from the tribunal. In practice, this is very rare the case that the parties will agree to give permission to a party to take this matter to a court, or the tribunal will agree to give permission for a party to take this matter to a court. I think Section 32 can be amended to allow a party to bypass the other party's permission and the tribunal's permission and ask directly the court for leave to apply. This will save time, this will save costs, and will increase uncertainty. So in deciding whether to grant leave for a preliminary determination of the tribunal jurisdiction, the court itself will be able to review whether the application is one that should be allowed and ensure that Section 32 is not abused. I will stay here. I think I'm happy to discuss furthermore, but overall, let me also again congratulate one more Sarah, Nathan and their team for the tremendous work that they've done.
Thank you, Stavros, and thank you for setting out the sort of debate over Section 67, which I'm sure we're going to hear more about from our next two speakers. We're going to move now to Wendy Miles. Wendy is a barrister at 20 Essex, yes, and is a specialist in international arbitration and dispute resolution with a focus on private and public international law. She sits as arbitrator and counsel in international arbitration and in related proceedings in English courts. In the field of climate change, her focus is on mitigation and adaptation to challenges, in particular those arising out of existing private contractual domestic law and private international law frameworks. She advises investors in states in respect of climate opportunities and risks in the context of cross-border investment and aligning finance flows with the Paris Agreement goals. She works closely with the ICC and has represented it at the Conference of Parties on Climate since 2015, and currently co-chairs the ICC Working Group on Carbon Pricing, and is a member of our sustainability specialist group for the Chartered Institute of Arbitrators, for which we appreciate your work. We're looking forward to hearing from you.
Thanks, Mercy. And I would like to talk about a climate change point, but I can't leave that unanswered. And so Stavros and I were sitting together last week, and he is one of the most prepared arbitrators I've ever come across, but he did not prepare me that he was going to take that position on 68. So I think it requires some answering. I think what you said to me was, Wendy, you stick to 68, I'll do 67. First of all, Nathan and Sarah, spectacular job in confronting this process, taking on this ornery community and steering the course and staying in the process, because, you know, we frighten a lot of people off, and trying to get one unified view is never going to happen. But you have stimulated an extraordinarily important series of conversations and forced people to participate and really think about what's important to them and what's not important to them about this Act in a way that I have not seen in the 25 years that I've been practicing under the Act. So well done, and thank you both. Hang in there. I think you've got it sort of 99% right, but I don't agree with Stavros on 67. So just a moment on why I don't agree, and I actually think you do touch upon it really well in the paper. But the counterpoint, and Stavros said argument against, it's a consensual process. And Section 67 is an important safeguard to consent. I think that is absolutely fundamental. It's described as a theoretical objection to reform in the paper, but I think it's so much more than theoretical. And the reason why to answer Stavros's rhetorical question, why there is a difference and a point of principle in treating an appeal on an award on jurisdiction differently to treating an appeal on an ordinary court decision is because of that foundational consent. If you're in litigation, you don't opt into it. You don't need an active decision of consent to be in litigation. That's a matter of conflict of laws application. So you need this party consent that is sort of underscored by the one instrument that holds together our system of international arbitration that Julian alluded to, and that is the New York Convention. And I do agree with Stavros that there's neither practical nor principle basis to distinguish between section 67 and section 103. I think they do hook together very clearly. We all know section 67 relates to what we call domestic awards here, London seated award, or England and Wales seated awards, and 103 relates to foreign awards. But we also know, because the DAC report said so, and because the courts have said so, including Lord Steyn in Lesotho, that the New York Convention, as well as the Untitled model law, were in part provenance of section 68 and indeed section 67, referring to Article 5.1c in relation to 68 and 5.1a in relation to 67. So the two do hook together. And I think that's fundamentally important, that we think about, if we do fiddle with section 67, we understand that it's parallel with section 103, and we're creating an imbalance between the two if we fiddle with one and not the other. And if we fiddle with either of them from the status quo, we need to think about what that means against the New York Convention. And in that regard, to delve back into the history a little more, when ECOSOC was given the first draft of the New York Convention, which was an ICC draft, it wasn't the New York Convention on the enforcement of foreign arbitral awards. It was the New York Convention on the enforcement of international arbitral awards. And what the ICC wanted, very driven, heavily from Paris, but what the ICC wanted was this system of international arbitration that did sit outside the courts, that wasn't reviewable by the courts, that wasn't answerable to the courts. And the ECOSOC committee at the UN rejected that. And they said an award completely independent of national laws may involve ousting the jurisdiction of the courts of the country where the arbitration took place. And this, according to the committee, was unacceptable, as the exclusion of any control by national courts might lead to injustice and abuse. And that's why they put in that language of foreign awards. I think on jurisdiction, we can decouple jurisdiction from substance, and we do. And the decisions, the jurisprudence in England tells us very much that a section 68 review should never lead to a re-examine of the merits of the award, but they don't say that about 67 for good reason, because once the parties have consented to arbitration, once they've entered the arbitration arena by consent, then all bets are off on appeal. You've chosen your arbitrators, you've chosen your body, and provided they act procedurally properly and appropriately and independently or impartially, then you put up with their decision, even if they got the law wrong, because they may not even be lawyers. So even if they got the law wrong, you live with that, that's who you chose. But if you didn't choose them, if you never agreed to enter that arena, then why should you then be bound to their decision? And Stavros would say, well, if you didn't choose them, then under 72, you would not participate. Now, I was doing a little bit of sounding in chambers this afternoon, and I'm not alone to say I have never had the courage to advise a client of mine not to participate in an arbitration where it challenged jurisdiction. It's an awfully brave call. It's like, just leave them to it, don't participate. you know they're going to find against you if you do that. And you don't know what the court's going to do about it, even with the de novo review. So I think that's a very, very high risk decision. I don't think 32 rescues you either because of, as Stavros said, the reason for either consent of the parties or the tribunal's decision to refer it to the court. So that is a limited portal as well. So I think fundamentally, the commission report gets it right when it says that the objection is a classic case of pulling oneself up by one's own bootstraps. I don't think it is a theoretical objection at all. I think it's a fundamental, foundational stone of the entire system of international arbitration that parties have to consent. And if they don't consent, the decision of the body that they didn't consent to being in front of shouldn't have any effect on them if they wish to review it in a court. And then in practice, what's the practical implication of if we introduce this? Well, Jonathan, Stavros and I could be sitting as arbitrators in 2 parallel arbitrations, one seated in Paris, one seated in London, same contract, same model contracts, same parties, same tribunal. They could even be governed by the same substantive law, but different seats. So we can't consolidate because they're not compatible arbitration agreements, different seats. We make a ruling that we have jurisdiction. The same party challenges that in the French courts and in the English courts. The French courts can conduct full de novo review of the French seated arbitration and the English seated arbitration if they get there first. But the English courts can't conduct a full de novo review of the English seated arbitration if the amendment were accepted, but they could have the French seated. And so again, that imbalance, and even if you aligned 103 and 67, you still create that imbalance where I think you are putting the English courts, you're tying one hand behind their back in their ability to uphold the integrity of international arbitration on a par with every other jurisdiction in the world. And whilst every other jurisdiction in the world won't necessarily carry out a full de novo review, they can. And whenever we've chosen to do something different under the English Arbitration Act from the rest of the world, like Section 69, we've made it non-mandatory. But this would be mandatory. And so I wasn't planning to talk about 67 because Stavros had told me I didn't need to. You'll keep. But I did just want to say very, very quickly, if I may, Mercy, just on Section 68, can I do it really quickly? I think there is a little bit of a lost opportunity on Section 68, and that is in relation to transition of systems to align with the Paris Agreement. So climate change mitigation and adaptation. And I think the point is this. Under Section 68, I should say that if you've read the report, the climate change does make it in there on the minor points chapter, but operational, so reducing carbon and in the operation of the conduct of arbitral proceedings. Important, valuable, really pleased to see it there, but I think there's a more exciting substantive point that could make its way into another iteration of the report. And I'm not proposing an amendment to the Act, but I think the DAC report has influenced the jurisprudence on how the courts deal with excess of mandate for failure to apply the proper law. And I think the DAC report, and again, it's Lesotho, it's Lord Steyn, has read excess of mandate for failure to apply the law very, very, very narrowly. And using clause 69 to say, well, if you wanted an appeal on point of law, you'd have preserved it under 69. So you can't use excess of mandate under 68 for what is effectively a point on law. Now, Lord Steyn, he distinguished between non-application of the proper law and failure and wrong, non-application of the proper law and non-application of the proper law. He said non-application, yes, reviewable, but wrong application, no, you live with the tribunal you chose. In practice, and the way the decisions have flowed since 2005, there really has never been a case on non-application of the proper law, because once you get into what the award did, it's quite difficult to say, well, they referred to Mozambique law, so they kind of decided it didn't apply. So they took their decision on that. I'm worried that the approach of the Paris Agreement, which is a bottom-up approach of each of the 197 countries, gets to legislate on its own governing laws on the application of climate change mitigation laws and climate change adaptation laws, that our very narrow approach to failure to apply the proper law as an excessive mandate will not leave any opportunity for our courts to set aside an award or send back an award that fails to apply new climate change related laws in the place of performance of the contract and or in the place of registration of one of the parties to the contract. And I think if we let arbitration become a loophole, that body of law that is growing exponentially every year all over the world, and which is in the very doorstep of our business day to day, its energy, its infrastructure, its land use, and its industry. If the court's narrow approach to excessive mandate for failure to apply the law never lets them set aside awards on that ground, then I think we run a potentially very big risk of having a New York Convention that operates in a manner that's inconsistent with the Paris Agreement and the UN Framework Convention on Climate Change. And there we have inconsistent treaties, and we all know under the Vienna Convention where that puts us. So the most recent treaty takes precedence. So we don't want to end up there. I think the Commission report could make a point to say, you know, excessive mandate is not intended to preclude the ability to review for failure to apply the law, including the law of the place of performance or the law of registration of one of the parties.
Right. Well, now we're going to hear from Jonathan, and I know Stavros will want to make further comments, but before we want to get with the audience involved in the discussion and in the debate, and before we do that, we want to hear from Jonathan. Jonathan Wood is an arbitrator and seasoned dispute resolver with over 45 years experience. He is a partner in International Arbitration Group with RPC, having recently represented the winning party in the much talked about Kebabji and Coot Foods case. He is currently the chair of the Chartered Institute of Arbitrators Board of Trustees, chair of the London Chamber of Arbitration and Mediation board here in London as well. And full disclosure, I also sit on that board. And has recently been elected as president of the Chartered Institute of Arbitrators for 2024.
Thank you very
Congratulations.
much.
Jonathan.
Right. Well, thank you very much. And first, let me join the commendation that everybody has iterated about the work of the Law Commission. I join in and say what a fantastic job has been done in this regard. I'd like to make two general points. Firstly, that is that I think when we're looking at arbitration, we should look at it in almost what I describe as a holistic way. It is not just the act, but we supplement it with the drafting of the clause. And over the years, since 1996 and before, we have seen the emergence of many institutions who have written up their own rules of arbitration, which sit side by side with the legislation that we are dealing with, whether it be in this country or whether it be in other countries. And I think it's worth reminding ourselves that this piece of legislation is the framework alongside which there are other elements when looking at arbitration. the drafting of the clauses in agreements on the one hand, and the rules which have grown up to supplement or to work alongside the framework that the Act represents. The second point that I think is also worth making, and that is that we are very blessed, if you like, to have a judiciary which is extremely skilled in arbitration matters. They come up through the ranks, through the bar, and they go to the commercial court or other parts of the judicial system and have great experience in acting as gatekeepers, if you like, in many respects of the Act. And I think that we should never forget the role that the judiciary provide in this regard. The other general point that I also wanted to make is that we are talking about, or so far, everyone has been talking about the Act in terms of it being an international, looking at it from an international perspective. And I don't think we should forget that the Act also applies to domestic arbitration. And I think I was struck when we appeared at the APPG the other day, when the representative of RICS made the point that they deal with something like 10,000 arbitrations a year. And that, eclipses all the institutional arbitrations that we find all around the world to some considerable degree. So I think it is just worth remembering that we have to look to the home crowd as well as the away crowd, if you like. Sorry for the football analogy, but there we go. But yes, I do think that that's very important and we should not forget that. And there is something to be said for that. I've been asked to look at this from the sort of maritime and insurance point of view, that being sort of where I grew up, if you like, in the arbitration world, and sort of, if you like, flowered from there into the broader range of arbitration. I think that one of the areas which is most important for the discussion is the issue of impartiality and independence. The Chartered Institute made submissions. I see one of our counsel who appeared in the Supreme Court in our audience on that issue. I am pleased from the perspective where I have practiced in the past in the maritime and insurance industry that we are keeping it as impartial and we are not introducing independence. And this is where I think that we have to look at the situation from a holistic point of view. If we want independence, then we can either deal with it in the clauses or in the rules that apply. For example, in the LCIA rules or the LCAM rules, there is a provision for independence to supplement the narrow impartiality point of view. But I do commend a continuing duty of disclosure. I think summary disposal is very important. I think that the paranoia, procedural paranoia, has taken a real grip. And I think in many matters, I mean, they say, follow the money. And I think at the end of, many cases are all about following the money. And summary disposal of many, many cases is something that will be welcomed so that arbitrators can deal with this, deal with what essentially is debt collecting on a robust way. So I commend this introduction of the summary disposal provisions, which sort of, I hope, will sort of give some fillip to arbitrators sitting. With regard to section 44, I think in broad terms, really all we are saying is, and I think this is the point made by the Commission, what we're doing is saying, well, look, all we're doing is saying we're giving to the arbitrators the same powers as the court has, nothing more, nothing less. But on emergency arbitrators, I have to confess, historically, I was a great skeptic. There was a phrase that used to be bandied around when emergency arbitrators were first talked about, particularly at the LCIA, and that is an order of the emergency arbitrator will never stop the ship sailing. And I think that anything that helps now that we have emergency arbitrators as part of the landscape in international arbitration and in the maritime world, anything that supports the obtaining of relief in that regard is to be commended. The other point I would like to make is on section 69. I think the maritime community in particular and the insurance community have always liked the idea of an appeal on point of law, and that sort of perhaps the audience historically about the attrition of English law as a result of there not being enough cases appealed. I think that section was a bit of a sop to them, but I do think that it is something which the maritime and insurance perspective and community do like the opportunity to have the opportunity to appeal on point of law. At what level, whether it should be easier or harder, that's a matter for discussion. But I think it should be retained. And again, it comes to the point that I make earlier, you can always opt out of it, either in the clause or in the rules. Last but not least is the law of the arbitration agreement. ENCA and of course the case that Mercy referred to, Ciarb and Coote, dealt with the law of the arbitration agreement in some considerable detail. And one of the points again that was made at the APPG is, couldn't we possibly codify what is a very, very lengthy judgment in ENCA and make it rather more simple and say, well, look, in certain circumstances where the host contract provides for a choice of law, then that should be the law of the arbitration agreement, and absent it, it should be the law of the seat. It sounds very simple. As Nathan said, when he was trying to summarize it, it is never as simple as that. But I think it is something that might be considered, if it only for those from overseas when looking to the Arbitration Act, if we could in some simple way provide for the law of the arbitration agreement, I think that would not be too bad a thing. Of course, talking about second bites of the cherry, section 67 and everything like that, we mustn't forget section 103 of the Act. And of course, that was the basis upon which the Ciarb and Coote case was litigated on enforceability and whether there was in fact a valid arbitration agreement at all. So there are other routes to having your second or third bite of the cherry under the provisions of section 103 and section, or the equivalent, it was taken of course from the New York Convention. So those are the views that I put forward, having taken soundings from that sector of the community that uses the arbitration. I mean, we only have to look at the statistics to see how many cases the LMAA deals with, that GAFTA, FOSFA deal with on each year. They are significant. And I think their voice needs to be heard. And I think that they have plenty to say about it. So thank you very much.
All right, thank you to our experts for your views and for getting the discussion started for us. Now comes the point where we are looking for your views. This is going to be more of a town hall type setting rather than a traditional Q&A. But we just ask that you keep your comments as succinct as possible. Where is the microphone? How are we doing this? For them?
Just want to walk up front.
Right. So because of the microphone setup, you're going to have to come up and actually come up here and give us your comments so that the audience online can hear you, because we're using a sort of a telecom. Yeah. So Wendy's got one on this side and I've got one on this side. So yeah, if you'll come up and basically like you're giving a presentation in school, I'll be the teacher and call you up to give your views, to give your input on anything that has been raised here tonight, or things that have not been raised that you think are important. But keeping in mind that this is to assist the Law Commission in their work, rather than simply to debate one another. And for those of you who are online, Sorry, for those of you who are online, we invite you to put your comments in the chat and we will read them out here in the room. Right. Who wants to, I saw some hands go up. Mr. Carducci, Professor Carducci.
Yes, good evening, everyone. Again, congratulations for the work, outstanding work by the Commission. Very briefly, because we don't have time. First, a general remark. There has been a number of references to the New York Convention, which is normal. However, let's not lose sight of the fact that under Article 5 of the New York Convention, all we are talking about is recognition or non-recognition, enforcement or non-enforcement, which is not an appeal. So when we are talking about articles, section 67, 68 of the Act, those are grounds for challenging the award. And as we all know from, for example, 67.3, the court may order following the appeal, either confirm the award, vary the award, or set aside the award, which is completely different from what we have under the New York Convention, where the outcome is completely different because the courts will either grant recognition or deny recognition, either grant enforcement or deny enforcement, which is completely different from setting the award aside. Then, of course, I will be very brief because other people wish to take the floor. I'm a bit uncertain about the part on independence and disclosure. Basically, the Commission maintains the position of the Act that does not impose a duty of independence. I think it's absolutely true that there might be a duty of independence by contract, by the applicable arbitration rules. That's we all agree. Anyway, I do have a bit of problem when I read in 1.126, so page 4 of the summarized version. We think that if an arbitrator is impartial, it does not matter if they are not perfectly independent, as long as any connections are disclosed to the parties so that the parties can consider the matter for themselves. I have a little bit of difficulty with if an arbitrator is impartial, it does not matter if they are not perfectly independent. Of course, impartiality is one thing, independence is the other, but independence is broader than not having a connection to the party having appointed. So I think we should be, the drafter should be a little bit careful on this, because in other jurisdictions, the requirement is both having independent and impartial arbitrators. Both are requirements under the arbitration law, not only the rules of a given institution. So, which is quite different. So, personally, I'm a bit skeptical about excluding impartiality or generally, because the message one sends is that all that matters is independence. But it's a bit hard to see how can an arbitrator be impartial, being dependent. Again, of course, they're different, independence and impartiality. But this sentence, it does not matter if they're not perfectly independent. It's a little bit problematic. Thank you very much.
All right, thank you. Is anyone? All right, I'm actually going to have you scoot your chair up here, and so you can. Yeah. So we have a couple of comments coming in online.
The first question is on immunity of arbitrators, and they ask, could Section 29 immunity continue upon resignation as the default position, rather than having to be sought from the court as relief from any liability incurred by him? This would lend more support to the immunity and clarify that a party has to apply to displace immunity.
Does anyone have any comment to that? Okay. And then someone is asking if anyone on the panel has actually been involved in a Section 72 case.
Yes.
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 In trust.
Okay. Yes. The answer is yes. Several people in the room have. All right. Let's hear from James. I think he wanted to come up, and then.
joint branch arbitrator. The Commission has been doing a fantastic job, and one of the challenges it's had to face is the diversity of the arbitration community in this jurisdiction. And that includes the diversity of the international arbitration community. And I was very pleased to hear Jonathan just now speak up for shipping and commodities. I have to say that I was disappointed to hear Julian Liu do the opposite when he spoke, because commodities and shipping are fundamentally international. That is actually encapsulated in Articles 1 and 2 of the anti-trial model law. Sale of goods and shipping are part of international arbitration. And 25 years on from the Act, the arbitration community in London, which includes institutional arbitration, as well as ad hoc and trade association arbitration, we are all thriving. Let's be an inclusive international arbitration community. And from that point of view, I also have to express my disappointment that the panel, with all due respect to them, and it's been an extremely interesting discussion, is not representative of the fellowship of the Chartered Institute of Arbitrators. Cedric Barclay, former president of the Institute and of the LMA, London Maritime Arbitrators Association, is commemorated here in the Marriott room, which it seems to me nicely encapsulates the inclusivity that we really ought to be striving for. And I mention this because there is a tendency for the term international arbitration to be appropriated to a certain kind of international arbitration. And when we're talking about such things as Section 69, and Julian Liu referred to international users, he was talking only about a certain kind of international user. The project, the one-off big ticket arbitration of the kind that goes to the ICC, and which indeed happily with the Act, more and more of that kind of case does come here. But that is still one community, and we should be very careful to make sure that we are inclusive. That was my main comment, but I also just wanted to ask one question, if there's going to be time. I was extremely interested to hear Stavros's thoughts on confidentiality, and I would tend to agree with him about public procurement contracts. And I was registrar of the LCA at the time of the Raytheon and Home Office case, a case which caused a great deal of stress to everyone in the Secretariat because we had to keep it completely secret, and we did a very good job at that. But then there was a mishap in the reasoning of the tribunal, unfortunately, and it ended up in court where confidentiality was blown out of the water. But my question there is, how do you actually draft the exception to confidentiality, and how far does it go? Because I completely agree with Stavros on the need for the public interest in a big project like that. But you also have business secrets, you have IP secrets. How do you actually deal with that? And don't you then just come back to the same drafting problem that there was with the 96 Act in the first place? That was all. Thank you.
Sorry.
No, I absolutely accept that there's a difficulty in approaching the drafting of such a provision. And I think that's the point also that is in the consultation paper, where they say, well, we acknowledge that in certain areas of dispute, including procurement contracts, there is a public interest to exclude the question of confidentiality, but we have difficulties in starting articulating the rule and then articulating the several exceptions. I understand. What I'm just saying is that if there is an accepted point of principle that we need to somehow exclude confidentiality out of it, we ought to find a way to draft a proper exception out of this. That's all I'm saying. But I accept very much the point that it's a difficult one to do, of course.
Okay, let's take another online comment.
So we have a question from Karina Albers, and she asks, regarding emergency arbitrators, this is an invention of arbitral institutions. Ad hoc arbitration does not need to have the call to does not need to call for emergency arbitration. And I think the Act is an excellent basis or foundation for ad hoc arbitration. Nevertheless, do you consider it necessary to introduce emergency arbitrators to the Act?
I think at the moment what institutions have done, and there are some exceptions to this in Hong Kong and Singapore, I think, but what institutions have done is introduced a facility of emergency arbitral orders, and they're not awards. And so they're not enforced on the same basis as awards, and that's the weakness of them. So as has happened in, is it Hong Kong or Singapore? Is it both? It's definitely Singapore, both. The amendment there to overcome that was to treat all emergency decisions, orders, or frankly, all orders as awards. Now, I don't think that is a solution. I know certainly I've drafted some orders that are not intended to be treated as awards, and it'd be inappropriate to do so. So we do have a vagueness globally, not just here, about what the status is of an emergency arbitrator decision. So we can keep treating them as sort of fake awards, pretend awards, almost awards, pseudo awards. But that's what the situation is. So in a perfect world, we would clarify that. I'm not sure which side of the fence I would fall on clarifying it. Should we make them all awards? I don't know that I'd vote in favour of that. But at the moment, I think there is a level of uncertainty, which is not ideal.
All right, we have one more comment online that we're going to read, and then we're going to go back to the room. How long do we have? Okay, we'll keep going as long as.
When does the football start? Oh.
We will turn it on when we're done. So it's an enticement to move along. All right, let's hear from the online.
This is a question from Julija. She asks about explicit provisions for summary disposal. Would these provisions be opt-out or opt-in, or have some other format? She leans towards provisions being opt-out, but that should be very grateful for clarification.
What are they recommended? What's in the proposal? Opt-out, yeah.
Nathan, can you?
So the current consultation paper, the provisional proposal is that they be opt-out, so parties can agree that they apply or agree that they disapply, and it is one of the questions that we ask consultees whether they like that suggestion.
Okay, thank you. Answer given by Nathan Tamblin, lawyer for the Law Commission, who's also here with us in the room.
And even if it were opt-in, a lot of the institutional rules would probably be that opt-in now as well. Certainly the ICC rules would.
All right, I see people running for the doors already because I mentioned that
wearing his red and white scarf.
no doubt where that man's loyalties lie. Do we have any more audience members who would like to give any comments to the commission before we tie up?
Just while people are thinking, can I just make one observation on?
I think Audley is ready.
Wait.
Come up, give us your thoughts while
Just while you're making your way up, can I just make an observation on confidentiality? This anchor decision on the law governing the arbitration agreement, not defaulting to the law of the seat, but potentially being the substantive law of the contract, which may not be the law of England. So you can have an arbitration seated in England, the Arbitration Act applies, but English law doesn't apply to the arbitration agreement. With confidentiality currently governed by an implied obligation of confidentiality under English law, if that arbitration agreement wasn't governed by English law, but the arbitration was seated in England or Wales, that implied duty of confidentiality under English law wouldn't come into it. So currently, because of that anchor case, we have differentiation in the approach to confidentiality under English Arbitration Act governed cases. I don't know whether you fix that with the Lord Hoffman proposal on anchor or if you fix that with putting confidentiality, but right now we do have another differential. which I don't think is ideal. Thank you. Sorry, Audley.
Ladies and gentlemen, Sarah and Nathan have heard my views, one on the paper, which I think is brilliant, well thought out, well considered, and very balanced. They have heard and read what I've said about section 67 and the example that they have. So I'll be very brief, but just to contribute to the debate is that we had a case 4 days before a very eminent tribunal where the respondent challenged jurisdiction, leading and junior counsel, full legal team, lost. And then they went and challenged that in court, in the High Court. 5 court weeks were required to decide that jurisdiction question because they were allowed to bring in new witnesses, cross-examine the same cohort from our side. It was an enormous amount of money and it achieved the same result. Now, one can't decide things by the basis that it achieved the same result, but it was just a very bad advertisement for England. When we are competing with those jurisdictions in Europe that have been mentioned, and in Singapore, and in Dubai, and many others, the cost and time it takes to arbitrate, including any court processes, is quite a disincentive. And I suggest we must address that. And one of the ways of addressing it, as the Law Commission has put out for consultation, is to restrict the ability of parties that have participated in an arbitration, lost on jurisdiction, to run the whole thing again with new evidence or additional evidence with additional witnesses at huge cost and expense. Save those exceptional circumstances where some fraud has been discovered that wasn't discovered before with reasonable diligence. That sort of thing, of course, is an exception. So I support the proposals that there should be constraint. I think it's a somewhat false equivalence to say, oh, well, France would do it differently. France or Switzerland would never have a 5-week hearing. So it's not the same. If it goes to de novo review in France, then it's going to be much shorter, it's going to be faster, it's going to be cheaper. But that is to repeat myself, and my apologies to Sarah and Nathan. But on this day, and something that I hadn't really paid very much attention to, although we certainly did, and that is a question of discrimination that's been brought to the attention of the LCA quite recently, and I don't have a mandate to express the view of the LCA, so Matt will be writing it. But just imagine this evening, imagine, what is it, 3 weeks forward. Imagine England don't lose by more than 4 goals this evening. Manage they get through. It's the final of the World Cup. You're playing Germany. That's the 89th minute. Or the way that FIFA is extending time, it's going to be about that sort of 115th minute. There's a call for a handball. It's presently a draw, and there's a call for a handball by the Germans against England. What does the German referee do? Imagine the whole of England would be aghast. No offense to Germany, but as you know, there's a bit of a history in football games with Germany. And I think that's where we need to be really careful about an arbitration. We've had a very high-profile case about nationality. It's not always rational. As I give my example, I can use my New Zealand nationality and my Irish nationality to do arbitrations, to be an arbitrator involving UK parties. It's fine, even though I've lived more than half my life here. So it's not totally rational. It's not always totally logical. But I would just say, when you're looking at discrimination, of course there should not be discrimination. Of course there should not be. But just be careful when you look at that, it doesn't have unintended consequences, because I think the international community, logical or illogical, is reasonably comfortable with the nationality issue, that the sole arbitrator, and this, of course the parties can agree, but the sole arbitrator or the chair of the tribunal will not be a nationality of either side, unless they agree.
I think that's the actual example we use in the report to say this is when it would be okay, don't we? Of nationality.
Yeah,
so if it is, I mean, absolutely. But if it's if it can get within the proportionate means of achieving.
People have been, what we've been hearing, people are not sure about where the proposal might be going on there.
So if we did do that,
a bit of clarity,
we would need to emphasise that point. Yeah, nice. Thank you.
Okay, useful. Thank you. Okay.
Can I just add just one comment just on the 5-week hearing, which sounds diabolical, but that in terms of court case management, the recommendation from the courts is having the opportunity to review a section 67 on the papers only, as you can currently do on section 68. And that would address, I think, potentially more directly and more effectively the ill that Audley identifies, which is one of court case management, as opposed to a fundamental issue under the Arbitration Act, which I know you know about because it came up at the Combar event. Yeah.
We have 2 quick questions that have come in online. The first one from Ogogo Okuega, who's asking if it's ever possible for the review to come into conflict with the New York Convention and what would happen in that situation.
For our review.
The section 67 review.
Oh, I see.
Oh, does he mean that, or does he mean your review?
It says review.
Well, okay,
I imagine that's
So there, we are explicit, for example, when we're discussing discrimination, that any changes that we make to the English Arbitration Act might have consequences in terms of recognition of an English-seated award under the New York Convention. We discussed that explicitly. That is one of the challenges of trying to do law reform to make sure that domestic law is as good as it can be when you've got underlying that an international convention that is 65 years old. And it's something in our report, in our consultation paper, that we've been explicit about. We have tried to suggest pragmatic answers why any non-alignment is more apparent than real. But ultimately, we ask consultees, is this a point of reform where it's more important for England to do what is the right thing and let New York Convention take care of itself, or do we need to stick more closely to a 1958 set of moral values? Now, I'm putting that in quite a pointed way because that's the way that it's put in the consultation paper, but we do want to hear people's views on that, so please do come in. If the question is more specifically, do our proposals under section 67 contradict the New York Convention? Well, in our consultation paper, we say not, but the panelists today have suggested, some of them have suggested maybe it does. And again, we'd like to hear your views on that.
And then we have a quick question from Joe Kelly, who's asking about whether or not the 96 Act applies to Northern Ireland as well as the UK, because we have a tendency to say England and Wales, England and Wales, England and Wales. And I think the point is it also includes Northern Ireland. So the answer is, Joe Kelly, yes.
And anyone from Northern Ireland listening, please do write in. We have made contact with the Northern Ireland Bar and the Northern Ireland Law Commission, and with Irish publications that cover both north and south of the border. We do make strenuous efforts to reach out to everybody. If someone from Northern Ireland has particular views, we'd like to hear them.
All right. We are well over time at this point, but we do still have comments coming in online. I'm going to look to the team to tell me whether we should.
I think maybe we could capture the comments and then we could always pass them over to the Law Commission afterwards. But I think we've probably reached
Yeah, so for those of you online who have further comments, do go ahead and write them in, and we will copy them and send them along to the Law Commission. And with that, thank you very much for coming and participating in this very interesting discussion. And
I just have 30 seconds.
And
more.
yes, we'll give the last word to Professor Green.
2 points. One is that I should have said this at the start, but I'm always happy to take criticism and blame. But seeing as everyone's been so nice about the report, I should definitely emphasize that is mostly down to Nathan, with extensive help from Richard, because everyone's put my name first when they've complimented it in there. So I need to underline that that's down to Nathan. And also, and thank you for this reminder, Jonathan, that please do put your comments in writing. So everybody online, everyone here, if you haven't already, and you want us to take formal recognition of them and detailed recognition of them, please, you've got until December the 15th, do so.
And it's only if they're in writing that they will be taken into account.
Yes.
By and large.
Yes.
All right. So everybody get your comments in written form by the 15th. And with that, for those of you online, thank you for joining, and have a lovely rest of your day or night, wherever you are. And we will retire to the snacks and make sure the game is on somewhere for people who are interested.